Okay, I think we have everybody. Are you ready, Ms. Rose?
I'm ready.
All right. Let me admit the council. Good morning.
Good morning.
We are live streaming right now. I'm going to go ahead and I'll wait a couple of minutes for the, I think it's, is it Mr. Edie that we're waiting on? Yes.
No, Your Honor, it's actually me, Elizabeth Brab. I'm doing the argument for,
Okay,
but I am just now changing my name on the screen.
that's fine.
And hang on 1 second, I'm not appearing. There I am.
There you go. All right, thank you so much. All right, can you please call court?
The Court of Appeals for the 8th District of Texas is now in session.
And the court calls case number 08-20-00200CV, EMO Trans versus Inmoveria Axial. And we shall begin. Let me make sure I have, wait a minute, I think I've lost somebody. No, I haven't. All right. Ms. Brab, you're going to go ahead and you may begin.
Thank you, Your Honor. May it please the court. This appeal involves the question of whether Texas courts may properly exercise personal jurisdiction over a New York corporation to resolve alleged liability for the non-payment of rent by one Mexican company to another Mexican company as to a warehouse located in Mexico. In this case, EMO Trans is not subject to either specific or general personal jurisdiction. As to general jurisdiction, the law is settled. As a New York corporation headquartered in New York, EMO Trans is not at home in Texas, as is required for general jurisdiction. The trial court did not specify the basis for its denial of EMO Trans special appearance. Therefore, EMO Trans briefed both issues, the general and specific jurisdiction issue, for this court. However, Axial essentially concedes the general jurisdiction issue by failing to respond to EMO Trans general jurisdiction arguments. Therefore, specific jurisdiction is really the only remaining issue before the court. And as for specific jurisdiction, the law is also settled. Axial's claims do not arise out of or relate to any of EMO Trans contacts with Texas, as is required to comport with due process. Furthermore, Texas has no legitimate interest in adjudicating Axial's claims against EMO Trans when this is truly a rent dispute between two Mexican entities concerning a leased warehouse in Juarez. The trial court's denial of EMO Trans special appearance should be reversed and judgment rendered dismissing Axial's claims against EMO Trans. To begin, I'd like to give the court a little background on the parties and the course of events that got us here, since we are talking about two different leases and three different time periods, and it can be a little confusing. In 2008, and please bear with me, a Mexican company headquartered in Juarez named Empresa Mexicana Organizadora de Servicios Logísticos. I'm just going to refer to them as Empresa from here on out, so you don't have to hear my terrible Spanish. Leased a warehouse in Juarez from Axial, also a Mexican company headquartered in Juarez. EMO Trans was not a party to that lease. EMO Trans arranged with Empresa to store its Mexican customers' cargo in the Juarez warehouse. Despite Axial's repeated and incorrect renaming of Empresa as EMO Logistics, the record reflects without contradiction that Empresa has no corporate relationship with EMO Trans. As Thomas Harlan, the executive VP, and CFO of Emotrans unequivocally stated in his affidavit supporting our special appearance, quote, Emotrans has no corporate ownership, no corporate affiliation or other interest in, and is not otherwise affiliated whatsoever with Impressa. None of Emotrans corporate officers are employees. Our corporate officers are employees of Impressa. They are two separate independent companies. During the course of the first lease in 2009, between July and October, Impressa missed a few lease payments. Axial, aware that Emotrans had its customers' cargo stored in the warehouse, reached out to Emotrans, knowing that Emotrans would have some bit of leverage as a customer of Impressa to encourage Impressa to meet its rent obligations. Emotrans did just that, reached out to Impressa. Impressa met its lease obligations, and Axial even notes in the record, pages 12 to 13, that those issues with the first lease were resolved, and the lease continued and expired in 2010 without any further issue. Anything involving lease one is completely irrelevant to Axial's claims here. In 2010, Axial then entered into a second lease with Impressa. Again, Emotrans was not a party to that lease. Impressa missed a few lease payments during the term of that lease between March and May of 2012. Again, the same course of events happened. Knowing that Emotrans was storing its Mexican customers' cargo in the warehouse, Axial reached out to Emotrans, hoping that it could then encourage Impressa to pay its bills. That happened. And again, the record reflects, page 13, Axial acknowledges that those issues were resolved. Any missed payments and communications and meetings regarding the March to May 12 missed payments are completely irrelevant to Axial's claims here.
Counsel, let me just be, and I want to be sure that I'm understanding the underlying record correctly. So at no time did your client ever pay any of the rent for behalf of Impressa. Is that correct?
Correct. We paid Impressa based on our agreement with them, and then Impressa paid its bills to Axial.
So your client never issued any checks for the rent.
Correct.
Okay.
So in 2014, Impressa again failed to make its lease payments. Axial's pleadings do not detail any communications, meetings, anything regarding those missed payments that started in 2014. There's good reason for that. By 2014, Emotrans was no longer storing its customers' cargo in the warehouse. Any leverage that Emotrans would have had as a customer of Impressa was gone. Axial eventually sued Impressa in Mexico to recover the unpaid rent. Emotrans was not a party to that lawsuit. The Mexican courts found Impressa breached the lease for failing to pay rent from January 2014 through October 2016. Judgment was entered against Impressa, not Emotrans, and then Axial domesticated that judgment in Texas and demanded payment from Emotrans. At that time, that demand was the first knowledge that Emotrans had of any ongoing litigation between Impressa and Axial. The underlying lawsuit followed. Based on the facts and the claims, Emotrans is not subject to personal jurisdiction in Texas on Axial's claims. When we're talking about specific jurisdiction, Axial needed to prove three things: that Emotrans purposely availed itself of the privilege of doing business in Texas, that Axial's claims arise out of and relate to Emotrans' purposeful contacts with Texas, and that the exercise of jurisdiction is reasonable under the circumstances. Emotrans does conduct cargo operations in Texas, but none of Axial's claims relate to those Texas operations or any of Emotrans' cargo operations in Texas. None of the alleged promises to pay by Emotrans have anything to do with Texas. Indeed, if rather than Texas, the meetings that Axial initiated that took place, the handful of meetings at a Starbucks in El Paso, had occurred at any one of the thousands of Starbucks around the country, Axial's claims would be identical. which plainly indicates there's no connection or tie to Texas. And a repeated focus on an invented relationship between Impresa and Emotrans by calling Impresa Emo Logistics does not help their jurisdictional argument. Impresa is a Mexican company with absolutely no ties to Texas. Axial began by urging that jurisdiction was appropriate under two sections of the Texas long arm section of the Texas long arm statute. Neither are applicable here. The first, Texas Civil Practice and Remedies Code section 17.042 subsection 1 provides for jurisdiction over a non-resident if the non-resident contracts by mail or otherwise with a Texas resident and either party is to perform the contract in whole or in part in this state. For the sake of argument only, even if Emotrans alleged assurances or promises constituted a valid enforceable contract, both requirements from that section are missing. Axial is not a Texas resident. It is a Mexican corporation with its headquarters in Juarez. And performance was tied to lease two, an agreement executed in Mexico covering leased property in Mexico between two Mexican corporations. That section is inapplicable. The second section is Texas Civil Practice and Remedies Code section 17.042 subsection 2, which provides for jurisdiction over a non-resident who commits a tort in Texas. Again, for the sake of argument only, even if Axial's fraud allegations were true, any fraud claim was time barred the latest in 2018. It's a 4-year statute of limitations on fraud claims, and the latest point at which Axial could have discovered the fraud itself states is in 2014, when it says that is when Emotrans refused to honor its obligations. Axial cannot rely on time-barred contacts as the basis for specific jurisdiction.
Counsel, if I can interrupt you on that specific point, your briefing cites a couple of federal district opinions out of Pennsylvania for that proposition. Is there any Texas authority or analogous Texas authority that, I guess, evidence that would be time barred or barred under some other procedural rule cannot be considered in a special appearance?
No, Your Honor. Those were the only cases we found where the issue had come up, and we found nothing similar in Texas. However, I would say that the Pennsylvania court's analysis rings true. It logically makes sense that it'd be a violation of due process to essentially force a litigant into a position where they would have to waive their due process rights in order to then merely prove that the claims are time barred. But you're correct, there is no Texas law on point.
And then the only thing about limitations is, I mean, from a summary judgment standpoint, it's always tricky because you have to determine when a cause of action accrues, and that in and of itself can be kind of a difficult process. So can you kind of address why, or address really the point, do we need to reach that holding that time barred communications have to be excluded for us to reverse the lower court's order here?
Yes, Your Honor. No, technically, what I would say is the time barred issue, we don't even have to reach that. It's really just the icing on the cake, because the Texas long arm statute sets a bar, here, but the Constitution determines where that bar is. And as the Texas Supreme Court explained in Michiana Easy Living Country v. Holton, a party may be able to satisfy the long arm statute, but not necessarily the U.S. Constitution, because, quote, the broad language of the former extends only as far as the latter will permit. And so because the constitutional due process limitations require that the claim arise out of or relate to the defendant's Texas contacts, even if we don't reach the limitations issue on the tort. And so even if it was determined that, well, there's a fraud claim and we're not going to go into the facts regarding the limitations, they still don't have, that claim is still not related to any Texas contacts.
Okay, and then just one final point, if you could. I noticed there's some stream of commerce cases that wind up in the briefing. Can you elaborate on your position that the stream of commerce doesn't have anything, or that's a different standard, if it is, to what we should be looking at?
Yes, we don't believe the stream of commerce cases have any relevance. This is not regarding a manufacturer putting anything into the stream of commerce. It's kind of a different standard about when you place something into the stream of commerce and where it causes injury. We're not talking about a product causing any injury here. So the stream of commerce cases aren't relevant except for the fact that they do continue to require some sort of connection with the forum in which the case is being brought. Does that answer your question, sir?
Yes, it does. Thank you.
All right, great. So back to the long arm statute and the committing a tort in Texas. As we just discussed, even if this court was not to reach the limitations issue, even if Axial could rely on the Texas long arm statute, specific jurisdictions still must comport with constitutional due process. And as the Texas Supreme Court has explained this requirement in M&F Worldwide v. Pepsi-Cola, there must be, quote, a substantial connection between the non-resident defendant's in-state activities and the operative facts of the litigation. Here, that required substantial connection is wholly lacking. Time and time again, Texas courts of appeals have dismissed claims for lack of personal jurisdiction, even when the defendant does business in Texas, because the plaintiff's claims lack the required substantial connection with those Texas contacts. Just a few examples. In Megadrill Services Limited v. Brickhouse, the Houston Court of Appeals held that considering only these defendants' purposeful contacts with Texas, the plaintiff's claims do not arise from or relate to the work performed in Texas. In Wilco Farmers v. Carter, out of the Texarkana Court of Appeals, held that there was no jurisdiction over Wilco because, quote, even assuming but not deciding that Wilco's contacts with Texas support a finding of purposeful availment, these contacts are not substantially connected to the operative facts of the appellee's claims. And in Denso Court v. Hall, the Houston Court of Appeals reversed denial of a manufacturer's special appearance because the manufacturer's purposeful contacts with Texas were unrelated to the claims that would be the focus at trial. That's exactly the situation we're in here. Because none of Axial's claims involve any of Emotrans' Texas cargo operations, Axial is attempting to create contacts by using alleged emails and Starbucks meetings initiated by Axial as the contacts with Texas. But all of those communications that are detailed predate by years the 2014 default by Impressa, which is the only relevant time period when the rent was not paid from 2014 to 2016. Lease 1 is wholly irrelevant to the Lease 2 claims because the non-payment issues were resolved. The paid Lease 2 obligations are also irrelevant. Any non-payment issues during that time period were resolved. Only the unpaid Lease 2 obligations are relevant, and Axial provides no communications or assurances from Emotrans during this period. Further, only defendant-created contacts are relevant. In the verified special appearance, Emotrans made it very clear that if anyone requested these meetings to discuss Impressa's failure to pay rent, it was Axial, not Emotrans. As the U.S. Supreme Court explained in Walden v. Fiore, the minimum contacts required to create specific jurisdiction must arise out of contacts that the defendant himself creates. As well, the contacts must be purposeful, not random or fortuitous. The defendant must seek some benefit, advantage, or profit by availing itself of the jurisdiction. As the Texas Supreme Court explained in Moncrief Oil v. OAO Gazprom, contacts are purposeful when a defendant's activity is, quote, aimed at getting extensive business in or from the forum state, end quote. No benefit in Texas or as to its Texas operations were gained by Emotrans by making any promises that Impressa would pay its rent on a warehouse in Mexico. There are no defendant-created purposeful contacts related in any way to Axial's claims. And finally, Holding Emotrans as subject to jurisdiction in Texas courts is unreasonable under these circumstances. While the primary concern is the burden on the defendant in defending the claims against it, the forum state's interest in adjudicating the dispute is equally important. As Emotrans has no purposeful contacts with Texas related to these claims, Texas courts have no interest in adjudicating a dispute between two non-residents involving no Texas property interests. Two cases out of the Corpus Christi Court of Appeals make this show this example pretty well. In EMI Music Mexico v. Rodriguez, the Corpus Christi court held that Texas had a substantial interest in adjudicating a matter involving a Mexican corporation because the dispute involved Texas residents and a Texas company. When you compare that to Juarez v. United Parcel Services, where that court held that adjudication in Texas of a lawsuit between non-resident defendants arising out of injury in Mexico and with no issues involving Texas or any of its residents violates due process as, quote, being contrary to traditional notions of fair play and substantial justice, end quote. It's unreasonable to hail Emotrans into a Texas court under these claims. When we look at the course of events and the burden of proof here in a special appearance, Axial bore the initial burden to plead sufficient allegations to support jurisdiction. The burden then shifted to Emotrans, and Emotrans met its burden by negating all the bases of personal jurisdiction. At that point, the burden shifted back to Axial to show as a matter of law that the court did have personal jurisdiction. Axial did not meet its burden. The affidavit from Juan Alvarez, the sole shareholder and founder of Axial, details promises regarding lease one, which are again irrelevant, detailing communications and a handful of meetings with Emotrans regarding missed payments in 2009 and 2012, which were all resolved.
Ms. Brabb, your time is up right now.
May I just conclude briefly?
Here, please.
So in the end, this controversy remains a landlord-tenant dispute between two Mexican entities regarding property in Juarez with no connection to Emotrans. Because Emotrans is not at home in Texas, and because Axial's claims do not arise out of or relate to Emotrans contacts, neither general nor specific jurisdiction is proper, and Axial's claims must be dismissed. Thank you.
Thank you. All right. You may proceed.
Thank you. Good morning, and may it please the court. The issue before this court is whether the trial court properly concluded that a Texas court has personal jurisdiction over a corporation doing business in Texas relating to claims arising out of promises and assurances made in Texas. The answer is yes, and Axial asks that the court affirm the trial court's denial of Emotrans' special appearance. I'd like to start first with clarifying what I believe is a fundamental mischaracterization of the plaintiff's claims in this case. Within this court and at the trial court, Emotrans repeatedly construes plaintiff's claims to benefit their arguments for a special appearance. You heard counsel explaining about lease one and lease two and what contacts could be considered. It's repeatedly called a Mexican lease issue, and that this is a landlord-tenant dispute that has nothing to do with Emotrans' cargo operations within Texas. But plaintiff's actual claims, as shown in their first amendment petition, are for breach of contract, promissory estoppel, fraud, and joint enterprise based on an agreement and representations of Emotrans to back the Mexican operations obligations. This was hashed out in the trial court. The trial court understood this, which is evidenced on page 41 of the reporter's record. The trial court says, okay, so let me make sure I understand. What we are trying to do isn't an enforcement of judgment. We're trying to get Emotrans to provide the financial backing of, let's just call it, Empresa Mexicana's obligations. And now you have this judgment that's an obligation to Axial. So we want to say, quote, Emotrans, we have this judgment that's an obligation of the Mexican entity that you promised to pay back. The judgment here is an independent financial obligation. It is separate and apart from the underlying lease. The underlying lease issues are not the claims that are being asserted here by Axial. Those were all asserted in the Mexican court and resolved there when there were defenses that were raised by EMO Logistics, the Mexican entity, regarding the payment of the underlying lease obligation. Once those defenses were all resolved and finalized, until that point, there was no basis for EMO Trans to make the demand on for Axial to make the demand on EMO Trans to cover those obligations as promised. So we're not talking about an underlying landlord-tenant issue, failure to make lease payments. The promises and assurances that were made in this case were that we, EMO Trans, would take care of anything that had to do with our Mexican operations, EMO Logistics, as it's referred to in the briefing and in our First Amendment petition. So I want to clarify that first. Second of all, I'd like to discuss the standard of review in this case. It's very important to the analysis of contested facts.
Before you move on, I'm sorry to interrupt, but that one went a little quick. Can you just slow down again? And since you're distinguishing the claims and saying it's not about the judgment, then what's the basis for the claim or claims?
Absolutely. So EMO Trans made promises and assurances that they acted on at different times in the chronology of this case, that EMO Trans would take care of any obligations of the Mexican entity. EMO Trans goes through great lengths to distinguish itself from the Mexican entity, saying that there's no affiliation whatsoever. The actual name of the entity is Empresa Mexicana, Organizadora Servicio de Logísticos, EMO Logistics. They go through great lengths to try and say there's no affiliation between the two, EMO Trans, EMO Logistics. It's just litigation flair is what they call it.
Okay, so, but back again to these claims. So there's two different leases, lease one, lease two. Then on the factual record and these assurances, do you concede that the assurances, if any, that were made during the first lease are irrelevant?
No, Your Honor, I don't. And here's why. The assurances is not relating to lease one or lease two. The assurance is we will pay any obligation of the Mexican entity. The obligation of the Mexican entity, in this case that Axial has sued on, is the judgment. The obligation is the judgment that was awarded in Axial's favor regarding the Mexican lease operations. So EMO Trans had made those promises and representations. We're going to cover whatever it is that is an obligation of this Mexican entity. So now Axial has a final judgment, an obligation that it tendered to EMO Trans and said, now please make good on your promises and your assurances, your agreement to pay these obligations. That's when EMO Trans suddenly took the position, we have nothing to do with EMO Logistics, with the Mexican operations, nothing whatsoever.
Counsel, if I could just follow up on that. Where in the record is there, evidence of a representation that EMO Trans would pay any of the debts of this Mexican operation? Because I'm looking at the affidavit, and there's 7 specific statements that are set out there, and it appears to me they all relate to specific missed lease payments, as opposed to this broad general statement that they would pay any debts, including, I guess, what you're really saying is there was a representation that they would pay the judgment of the Mexican court once it was finalized. And I want to, is that in the record?
So the record, you're correct, Justice Ali, that the affidavit of Mr. Alvarez is the evidence that's before the court as far as, what representations were made. So there's in-person meetings that took place in El Paso and elsewhere within, actually the in-person meetings were only took place within El Paso. There were also written communications that were exchanged back and forth within Texas there are some statements that say we've instructed our Juarez operations to immediately transfer the funds to you. Please be rest assured you'll be paid by our local office. I've instructed my Juarez office to pay no later than tomorrow. I'm sorry to hear about your comments regarding our Juarez management. They acted on my order to split this payment. There's also ones that they're discussing that they'll be in El Paso and Juarez next week to address issues regarding payment. And then the in-person meetings, those meetings were made, representations and promises were made there regarding the obligations that they had committed to pay. So there isn't anything in the record that specifically says regarding this judgment that wasn't, had until 2018. It's not specific to the judgment, but it was anything relating to these lease payments, this obligation that EMO Logisticos had to pay to Axial. Once that was finalized and there was a final judgment for this is what's owed under those lease, that's when that was tendered to EMO Trans for payment. Does that address?
Yeah, but and correct me if I'm wrong here, but my understanding of kind of lease law is if a lessee misses a payment, the lessor has a cause of action for that payment. And if they miss the next payment, then there's a separate cause of action for the next payment, and so on and so on. But landlords, typically will have an acceleration clause where they'll then accelerate the lease and sue only once. But if the claim arises for a specific missed lease payment, then how can a representation regarding, let's say, a 2010 missed lease payment carry forward to a 2014 missed lease payment? And then if that's the case, what reasonable reliance do you have that something promised in 2010 is going to carry forward to all the lease payments going forward?
Well, I believe that when you look at everything, the timeline and the chronology, there's evidence that repeatedly, if there's something that's an obligation, a missed lease payment, early on, that EMO Trans is saying, we'll take care of it, we've got it. We also have, the in-person meetings where they were also making representations to him that, and this will all be hashed out in discovery should the case proceed, saying that we're going to take care of whatever it is that's due and owing under this lease. So if you follow the kind of pattern of what was happening between these two parties, EMO Trans is always taking care of what happened with this lease issue. So once there was a default, there were certain defenses that were raised in the Mexican proceedings. EMO Logistics said that their defense was that the court had ordered them to stop paying Axial for the benefit of another creditor. So until that was all resolved, whether we figured out did they owe anything or not under this lease, there wasn't any amount for Axial to go tender to EMO Trans. So it's not just lease one, lease two. It's let's look at the pattern of their relationship. They're obviously, EMO Trans is taking care of these Juarez operations. They obviously have an interest in the warehouse, the lease space that's there. There's a pattern of them taking care of it. And then it's not until there's a final judgment where we say, okay, all the defenses to whether there was payment or not have been resolved here. Now we need to pay it, that all of a sudden EMO Trans takes this position. We have no affiliation whatsoever. And the trial court was not, for lack of a better word, was not buying the no affiliation whatsoever. The court states on page 19 and 20 of the reporter's record, I think it's, quote, Coinky Dinky and President Mexicana, I guess, the same initials. And the counsel for EMO Trans says that, I think the court's concern can be responded when you look at Mr. Harlan's affidavit, where he says, we have no affiliation whatsoever with Empresa Mexicana. The court says, well, they do. They do because at least factually, we know that somehow their logistical office here in El Paso was involved in the discussions, had to secure a lease in the Juarez warehouse. So there's some affiliation there. It might not be ownership, but we didn't just pull it out of the air that EMO Trans and El Paso was somehow involved in this lease agreement.
So Counselor, Justice Rodriguez had asked about the payments, and you're saying that payments at times were missing or missed, and then the conversations happened and then they were taken care of. But did Impressa make those payments?
I'm sorry, Your Honor, I don't think that there's any evidence in the record necessarily about whether those payments were made by Impreza, EMO Trans, how they were made. I'm sure that all of that will be hashed out in discovery, but
But you're making an assertion that there was this pattern developed because every time that Axial had conversations with EMO Trans, it resulted in assurances and payments. And so it sounds like you're linking the payments to EMO Trans making those payments. And so I guess I'm trying to understand, did Impressa make the payments?
Sure. I guess the reason I'm linking those is because what I'm trying to explain is that all of that relationship is appropriate for considering whether the court has personal jurisdiction over the claims right now, because it goes to Axial's reliance on these representations and assurances that these were going to be paid. So instead of looking at it as, okay, there was a mispayment, it was paid, mispayment, it was paid, as like an independent claim, we're talking now in 2019, or recently in 2019 when Axial tendered it, and whether Axial had a basis for relying on EMO Trans's representations and assurances that it would take care of things. And that's why those are relevant to the jurisdictional analysis.
Is there any evidence of detrimental reliance that your client, delayed in filing a suit or extended the lease or extended any gratuity to Impressa, but based on the representations?
Your Honor, I would defer to the statements in the affidavit and the pleadings in the first amended petition. But there is, we have pled the discovery rule in this case, which that there was no way for for Axial to know that those statements regarding assurances to pay the lease were fraudulent until the time that they tendered it and said, and EMO Trans said, we don't have anything to do with Impreza Mexicana at all. So as far as detrimental reliance, I mean, Axial had to resolve the underlying judgment in the Mexican court before it could go to EMO Trans and say, here's a final obligation that you've promised to pay me. So I guess there is circumstantial evidence that there was a delay before, waiting until the Mexican court resolved it until they brought it to EMO Trans. I hope that answers your question.
So the way that I'm kind of understanding it is that the Mexican corporation who signed the lease and didn't make the payments is kind of first in the line of debt. And so what they did was they resolved that by getting the Mexican judgment. But what you're, I think, trying to say is that essentially that EMO Trans is the guarantor. And so until you could reduce it to judgment, you weren't able to approach them for the payment of that judgment.
That's correct. So yes, there is a judgment against a Mexican judgment that was against the EMO Logistics.
Right.
Then that judgment was domesticated in Texas, which was then sought to be enforced against EMO Trans based on their guarantees or representations that they would pay. There is no written guarantee. These are oral promises. And also we have the affidavit that shows the written communications where there are talking about that there is a relationship between EMO Trans taking care of the obligations of the Mexican entity.
All right, thank you.
And just briefly, I don't have much time, but I would like to talk about the time barred contacts analysis. The claim is that we can't consider everything that happened before the claim by EMO Trans because it's time barred. First of all, Justice Alley, you pointed out that those cases are not Texas cases that they're relying on. They're federal court cases from Pennsylvania. And moreover, none of those cases discuss the discovery rule, which in Texas, the discovery rule is going to defer that cause of action until the plaintiff knows of the facts giving rise to the claim, knows or by exercising reasonable diligence should know. So that's been pled in this case. And in this circumstance where there are no findings of fact or conclusions of law that have been issued regarding the trial court's denial of the special appearance, there's all the findings that are to support the judgment are implied, so long as that they're supported by the evidence in this case, which, as I mentioned, that they are. So I wanted to briefly address that. I also, I'd like to address the substantial connection and the purposeful availment. The question then is whether the plaintiff's causes of action arise from or relate to EMO Trans's purposeful activities within the state. The EMO Trans's argument is that they had no affiliation and that there were no representations made to plaintiff. So as far as the no representations made to plaintiff, the Harlan affidavit, he states that EMO Trans, quote, never made any assurances or promises to plaintiff in El Paso, Texas, or anywhere else in the state of Texas or otherwise with respect to EMO Trans's purported agreement to pay plaintiff any rent for the lease of the subject warehouse located in Juarez, Mexico. That statement is directly rebutted by the Alvarez affidavit, where we've included specific instances where they are making representations in El Paso or from Houston regarding the payment of that lease obligation. So there's direct evidence rebutting that. And in the standard review in this case, where there's no findings of fact and conclusions of law, those findings are implied to support the judgment. I also briefly would like to address, and I apologize for kind of jumping around here, but I just want to hit some of the high points. The Texas long arm statute, EMO Trans argues that, as counsel stated, there's the three kind of categories within 17.042 of the Texas Civil Practice and Remedies Code. What counsel and EMO Trans is ignoring is the beginning of that statute, which says, in addition to other acts that may constitute doing business. Then it lists 1, 2, and 3. The Texas Supreme Court has construed this statute saying that it, quote, broadly allows courts to exercise personal jurisdiction, and it reaches as far as the federal constitutional requirements for due process will allow. So making EMO Trans's promises and assurances relating to its cargo operations within Texas are certainly doing business within this state. There's no dispute here. It's undisputed that EMO Trans is a worldwide or global logistics company. Even Mr. Harlan states that in his affidavit. It's clear from the evidence that was before the trial court and before this court that EMO Trans was conducting its global logistics operations, including managing its Mexican operations through El Paso, Texas, and its offices within Texas. It has 3 within El Paso, Houston, and Dallas. Just to conclude, I see my time is up, but Axial would pray that this court affirm the denial of the special appearance. In the alternative, Axial has pled, because it did ask for jurisdictional discovery in the trial court, and the trial court didn't rule on that discovery issue. It would ask that it be remanded for jurisdictional discovery to take place for the court's consideration. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. Let me hit some high points. First, I want to start with the implied connection between Impressa and EMO Trans based solely on the name. Now, EMO Trans was founded in Germany in 1965 by a man named Eckhard Moltmann. That name starts with an E, and then the first 2 letters of the last name are MO. That is where EMO comes from. The U.S. corporation was then incorporated in 1972. Eckhart was a shareholder in the company until he sold his shares about 20 years ago. So the company retained the name.
Some of this in the record, counsel.
It's not. I just want to say that Impresa Mexicana Organizadora, Impresa simply means company in Spanish, Mexicana is the location. So truly the name just means Mexican Organizing Company. And just Emotrans is a global company, as counsel stated. Obviously, those initials are not what Emotrans stands for around the world. Moving on to the standard of review and counsel's statement about the lack of findings of fact and conclusions of law. What Axial does not tell you is the rest of the story. So when a trial court does not issue findings of fact and conclusions of law with its special appearance ruling, all facts necessary to support the judgment and supported by the evidence are implied. But as the Texas Supreme Court explained in BMC Software, when the appellate record includes the reporter's and clerk's records, these implied findings are not conclusive and may be challenged. So the rest of the story is no findings of fact must be implied by this court because there's no findings of fact and conclusion of law. There is a reporter's record and a clerk's record in this case. Going to the Mexican lawsuit, counsel stated, well, they had to proceed through the Mexican court and all the defenses that could have been asserted by Impresa were, and it got to that point, and then there would be this judgment, and now they're turning to Emotrans to satisfy the judgment, as it claims, as it alleges we agreed to do. Emotrans was not a party to any of that litigation in Mexico. No, Impresa never asserted that there was going to be any covering there of its debts, any agreements with Emotrans to cover its obligations. So now coming to Emotrans and saying, oh, well, we already had our time in court where we sorted out the defenses and determined whether this rent was owed, and now it's your fault without us being part of that case is just a clear violation of due process. And finally, discovery. So Axial has, asked this court if you feel like there's a need for jurisdictional discovery, you could go back to the trial court. However, much of the discovery sought, and most of it, according to Axial, was to support its outdated pre-Daimler general jurisdiction argument. In the record, pages 223, 224, they've actually broken out the list and say, this is what we're seeking regarding our general jurisdiction argument, and this is what we're seeking regarding our specific jurisdiction argument. The general jurisdiction argument is resolved. This is a New York corporation headquartered in New York based on post-Daimler case law, and even this court in Western Technologies v. Omnivations stating U.S. Supreme Court case law has made clear that absent extraordinary circumstances, general jurisdiction is limited to those locales in which a corporate defendant is either incorporated or headquartered. General jurisdiction, the issue is essentially off the table, and we're left with specific jurisdiction. And their discovery requests for specific jurisdiction, we're left with 6. They involve wanting information regarding the pre-2014 meetings and communications at which Axial would have been present or initiated itself. It's irrelevant, or they have access to that information. And alleged lease payments made in Juarez by Emotrans that Emotrans has already unequivocally stated it did not make. There's nothing to be gained from jurisdictional discovery. All the facts are as they are. We have everything is in front of you here. In sum, a few Starbucks meetings not held at any of the 3 locations that Emotrans does have in Texas regarding none of Emotrans Texas operations are simply not related to Axial's claims in this case. It all centers around a warehouse lease in Mexico. Specific jurisdiction is improper, general jurisdiction is improper, and the trial court's denial of Emotrans special appearance should be reversed and the claims dismissed. Thank you.
Thank you for your arguments. Your case will be submitted today along with your briefs. And And we appreciate your participation and answering our questions this morning. Thank you so much.
Thank you, Your Honors.
Bye-bye.